All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Well, good afternoon and welcome back. 540-0580. Carl Rominger here answering your legal questions. So call in and throw them at me. What do you want to talk about? Divorce, custody, personal injury, why Pippa keeps getting dumped 3 times in 6 months. When you sit here in the WHP 580 studios, you go through the magazines that R.J. Harris collects. Okay, let's just talk about R.J.'s reading. Life and Style Weekly, Star, In Touch, People, the double special issue with 50 diet secrets revealed, and the National Enquirer. It's either RJ's collection or a teenage girl's. It's hard to say. Anyhow, 540-0580. If you have a legal question, call in. We'll answer here on the air. Let's see. One of my lawyer brothers is running for president, Rick Santorum, right? And good old Rick. Here's one of my favorite things. Rick's for tort reform, and he's going to, if he's president, going to help stop those evil lawsuits. But, back in 1999, his wife sued a chiropractor and asked for $500,000 in damage, not because she couldn't walk, not because she couldn't run, but because she had pain. And she needed $500,000. The jury gave her $350,000 for her pain, which the Santorums generously took and put in the family bank account. So just want to throw that out there. Every time you hear Rick Santorum talk about tort reform, I guess maybe he means it and maybe he's going to stand behind it. But he sure didn't return that money when the jury awarded it to his wife back in 1999. And I could get into Santorum on contraception. I can get into Santorum on abortion and some of his waffling there. But I think the contraception one's the most interesting. He says he would never vote to outlaw it, but he doesn't think it should be legal, and he doesn't think a court should force a state to allow contraception. I'm not sure what the birth control plan is he's going to push as president, but that'll be interesting. 540-0580. Barb, you're on the air.
Oh, hi. I have a question about adult adoption.
Okay.
In Pennsylvania. I did a lot of research, but what I was curious about is if now at 24 years old I want to have my biological mother and my stepfather and change my name, how does my father fit into that now that I'm an adult?
Well, okay, so who do you want to have adopt you?
My stepfather.
Your stepfather. Well, your biological father's rights still have to be terminated.
Okay.
But they can do that by consent, or a court can do that. And so, you still have to terminate that person. So you can't have 3 parents, right?
Right.
Last I knew that wasn't allowed, or there wasn't anybody. So that basically their role would be either just to sign off or for a court to terminate their status as parent.
Okay, so if they would fight that, now that I'm an adult, it doesn't matter what I want.
What you want matters, and that would fall and that would go in towards determination. Now, what the exact legal standard is, I have to be honest with you, off the top of my head, I don't know, because the last couple adult adoptions I've done have always been with somebody who, somebody's deceased, or there's no parent to be found, that sort of thing.
Right.
But long and short of it is, I've got to imagine that your what you want counts, and it's your best interest that matters for purposes of the termination. Obviously, they have some right of support or contribution from a child, theoretically, under the law. So I don't know what the legal standard would be, but I know that you wouldn't necessarily fail just because they were opposed.
Okay. Well, that's good to know. Well, thank you for your help.
The big question would be, we'd have to do a little research on the standard. And, of course, I know this is my famous thing where I always tell people, one of the reasons you hire a lawyer is because we know where to look. We got to go out and see what court cases have said and what the courts have said about what the standard is and what the issue is going to be. And then we can feel it out. Now, I got to imagine, though, a lot of judges are not going to put a lot of weight, particularly if there's a good reason. In other words, it sounds like you weren't raised by your biological father. Maybe you were, and that would make a difference. But I'm just going to, throw something out there and say, maybe you were abused by your biological father. That would probably go a long ways towards a court being convinced that the termination's better for your mental health, for instance.
Well, it's without getting into a lot of detail, for some reason he likes to still do things to affect me now as an adult.
Right.
I mean, I'm talking going as far as using my Social Security number to get credit, and it's just crazy.
Yeah, that's not good. That's not good. Well,
I just want to cut all ties.
And just so you know, I mean, in that type of adoption, because it's a step-parent adult adoption, it's not going to be overly complicated. So it's not something that you're going to need to spend piles and piles of money on either, not like an agency adoption. But obviously, if you resist, there might have to be a hearing on it, and that's where we'd want to focus our research.
Right. Well, when I looked it up, it said basically you still have to have a hearing regardless, and if there's nobody opposed. But I didn't know who the opposing party would be, because I'm thinking if my stepfather says it's okay and I say it's okay, I don't understand why anybody else matters.
Well, because theoretically, statutorily, and for other legal areas, there's a duty from parent to child and vice versa. And so theoretically, for instance, under one Pennsylvania statute, rarely enforced, highly controversial, subject to repeal, and often asked about on weekendappointment.com, there is a ability to cause, for instance, a child to pay for a parent's care in a nursing home, let's say.
Oh, okay.
And so if we terminate, society has an interest in this too, which is we terminate his interest in you, well, that may affect his ability to be paid for. So could you imagine a scenario where somebody came to court and said, well, I'm going to nip this in the bud. I'm going to get adopted by this stepfather, but we all know it's a fraud because I've got a lot of money and I don't want to be on the hook for caring for my father, who we all know is going into the nursing home, and we're going to let him get Medicaid.
Right.
So my point is there's a level of inquiry. The other thing is, obviously, because he has a right or interest in the familial connection, due process alone would require he at least be given notice and a chance to be heard. But as my civil procedure professor, Ed Hockney, used to say, civil procedure class was that due process means the right to be heard. Beyond that, no guarantees. And quite often it means all you do is get heard and you're still going to lose.
Right. Okay.
All right, Barb?
Well, good to know. Thank you for
All right, if we can help, let me know.
Okay.
540-0580, Carl Rominger here answering your legal questions. Jim, you're on the air.
Hi, Carl. How are you?
Good.
Hey, I have a question on a first-time DUI. I'm 52. It's first time. And it's not alcohol.
Okay.
Okay, they didn't do a roadside sobriety test or anything like that. They took me, because I was injured, to the hospital, did blood work, and they found out that I had certain legal prescription drugs in my blood.
And they could still make out a DUI on that theory. In fact, the Pennsylvania Supreme Court recently decided a case where they said that the government doesn't necessarily need a doctor to make out that case, although sometimes they would for impairment purposes. But we have run into cases where they've charged people, and quite frankly, they've charged people when you're at the therapeutic levels and where a doctor will come in and opine that you wouldn't be incapable of safe driving. But I think sometimes the police officers and the district attorneys get a little ahead of themselves because of the accident.
Right. They did a questionnaire, the Department of Transportation, and went through my doctor, and he said that I was quite, okay to drive on the medications I was on.
Right.
And it's, without getting into great detail, I mean, I've been on these medications for probably 7-8 years, and I was like 4 minutes from my house when the accident happened, and nobody was hurt, except I had to cut my head. That's why they took me to the hospital. They did the blood test, and it's in court now. I waived everything in the court, and it's in the trial process. And I have a law firm out of Lancaster, and basically I talked to him, and he said, fight. We're going to fight it.
Yeah.
So I'm all for that, because I guess my main question is, what is my worst case scenario? Like a year suspension on the license? And
this is a first offense DUI, no prior record?
Yeah, prior record.
You do have a prior record.
Mm-hmm.
That's why you didn't get ARD.
Can't get ARD probably, no.
Okay, so this is your first offense DUI, though?
Correct.
Okay. Well, you're looking at being treated as the highest tier. Can I put you on hold and grab you after the break here?
Oh, sure, absolutely.
All right, hold on here. 540-0580, Carl Rominger here answering your legal questions. When we come back, we're going to talk to Jim about the consequences of his first-time DUI. Welcome back. Carl Rominger here. Got Jim on the air. Jim, we're talking about your first offense DUI. Let me catch everybody up here.
Okay.
You were found to have prescription drugs or lawfully prescribed drugs in your system. For some reason, the government seems to think that rendered you incapable of safe driving. Your doctor doesn't agree, and your firm's going to take it to the mattress, so to speak, and wrestle it out. And your question was, what's the worst thing that can happen? Well, first offense DUI, they're broken into tiers. There's a low tier, a mid tier, and a high tier, but prescription drugs or illegal drugs or a combination of alcohol and drugs is treated as the highest tier automatically. In fact,
no alcohol whatsoever.
What's that?
There was no alcohol whatsoever.
No, I said I gave you three different options there: legal drugs, illegal drugs, or a combination of alcohol and drugs are all treated as the highest tier. Okay. So my point being, though, is that the legislature designed it as a fixed game so that more than half of all DUIs are in the highest tier. Okay, so you're in the highest tier. So your consequences on first offense DUI are a mandatory 3 days in jail.
Wonderful.
And a 1-year loss of license with a 60-day license suspension. Because an accident happened, however, they could apply some enhancements, and I believe you might get there might be a way to get a 90-day license suspension out of it with that enhancement, although that I'm not positive off the top of my head. I'd have to actually look at that. But realistically, you're looking at least a 60-day license suspension. Now, the bad news is the next 10 months are work license only. They're not an unrestricted license. So you're looking at a 1-year restriction on your driver's license. Now, of course, some of the listeners are going to be like, well, who cares? He was driving drunk. And you're going to be, no, folks. Jim was driving while taking prescription medications, which his doctor believes would not affect his driving, which you said you've taken for about 7 years now, right, Jim?
Correct.
And haven't had any problems.
Correct.
So I see this, though, and this is why I don't think your lawyer's giving you bad advice about fighting it. I see this a lot. There's an accident, and then there must be there has to be a reason for the accident, Jim. There has to be, right? I mean, that seems to be the mantra these days. There's no such thing as an accident anymore. There's got to blame somebody. Well, we're going to blame Jim, and we're going to blame Jim's prescription drugs.
Right.
Pretty soon they're going to be claiming aspirin did it, and it wouldn't surprise me if I get a case someday where that's the police's theory. Anyhow, long and short of it is somebody made bad charging decision most likely. But because it's a DUI, they're very remiss to dismiss them or withdraw them, even when they know they're wrong. And the prosecutor will take it to the judge and make the judge dismiss it because he doesn't want to talk to Mothers Against Drunk Driving and explain why he dismissed the charge, particularly if it's an election year. He would rather say the judge did it.
Can I choose? If it's going to go to trial, can I choose a judge trial or a jury trial?
You get a judge trial. You don't get a jury trial because the legislature made the maximum possible sentence 6 months in prison. And our United States Supreme Court says that while you can have a jury trial over any civil matter, $20 or more in controversy, for instance, or any criminal matter, says the Constitution, the Supreme Court said, no, they didn't mean any and all criminal matters. They mean only when they carries a possibility of more than 6 months in prison should you be entitled to a jury trial. So the legislature wrote the law in a way to deny you a jury trial and give you a judge trial only.
Okay.
So good news is if it was a second offense, highest tier, you would be entitled to a jury trial. So you have to repeat offend before you're allowed to go see the jury.
Wow. Well, this is, and I'm going to be very honest about this, that if I pled guilty and the district attorney wanted to, plea it out or something, I can't honestly say to my lawyer or the DA that these prescription medications caused the accident.
No, you would have
to be pleading guilty to something like with a question mark. Was I impaired? I don't know that.
Yeah, and we would do that. We'd probably have you plead no contest, meaning that you're not admitting that's what happened, or you're not saying those are the facts of the case. Right. The other option too is a plea to general impairment, which would carry no driver's license loss, no jail time, 6 months suspension or 6 months probation.
Okay.
So that's another possibility out there. Jim, work with your lawyers. Good luck.
General impairment, you called it.
Yep. Although technically those facts don't apply either because the general impairment of alcohol is the charge, but we just all pretend. All right?
Okay. All right, I'll talk to my lawyer about that. Thank you.
All right, brother. 540-0580. Jay, you want to talk about adult adoptions?
Yeah, Carl. Sorry about that. How'd I get to the phone? Barb called, and I kind of.
You trying to get adopted, Jay?
Well, no, I just got a question or a comment. Why would there even be such a thing as adult adoption unless it has financial repercussions, and I can understand some of those. How would technically an adult be, unless they were, impaired in some way. A normal adult.
All normal adults are impaired in some way, Jay. But but I know what you're saying, and the answer is, there's no particular reason why it's allowed.
Graduates, but no, I'm sorry. Go ahead.
No, there's no particular reason why it's allowed, except that the legislature doesn't put an age on adoption. So anybody can be adopted if they meet the protocols. And there's reasons for it. I mean, what you're doing is you're undertaking certain legal rights, obligations, and duties.
Right, and I understand financially or something could happen.
And that would be people's desire. The other thing we see sometimes is perhaps, and I don't know what Barb's situation was, but imagine that the father was sexually abusive of her, for instance, or the father was, and she was raised by the stepfather. Maybe she just wants a different dad, and why not give her legal recognition to that?
Dealt with when she was a child.
Well, but maybe nobody dealt with it. Maybe that's why mom and dad divorced, and maybe dad even went to prison, but nobody ever adopted her, and maybe now she wants to deal with it as an adult.
I assume the term, and I guess I'm wrong, that the term parent, the legal terminology of a parent, ended at the age of majority, but possibly not.
Well, no, there's still a parent-child relationship, and there's still statutes that talk about those things. And the other aspect of it is, I mean, and this is what's funny about it, right? It's like my buddy Rick Santorum would tell you, you can't have two consenting adults in a same-sex relationship because we can't just give people what they want. But when it comes to adult adoptions, I guess it is about what people want.
Yeah. Okay.
All right.
Okay.
Hey, enjoy your weekend. This is some really nice weather.
Yeah. Thank you. Bye.
540-0580. Who's next? Bill, you're up.
Hey, Carl, this is Bill.
What's going on?
You legal guru, you. Hey, I sold that rent house down in Northern Virginia, and I'm really happy I did that. And when the renters moved out, which was one of the reasons I wanted to get rid of the renters, they owe me $5,000 in back rent. I know where they moved to, but since you don't practice down there, is this even worth pursuing, or just say the heck with it?
It might be. It might be worth pursuing. If you go to weekendappointment.com and look around for some of the links on there, you should be able to find a link that'll let you talk to some lawyers from out of state. Legal
Good.
Match link.
Good.
All
Thanks
right.
a lot, Carl.
All right,
Thank
brother.
you. Bye.
540-0580. Got a little bit of time before the next break here, so who should we talk to next? John.
Hello.
Yeah, John. What's going on?
Calling for a friend of mine. He was working what was considered with his company full time, which was he was getting 32 hours a week, and they're going to demote him to part time, 20 hours a week.
Okay.
They're talking about a severance package if he quits, and they said, well, off the record, you can quit and draw unemployment. And I guess that's my question to you. Can
Yeah,
he quit
I mean,
and draw unemployment?
If he quits, he can draw unemployment. The answer is yes. If the employer's not going to say that he resigned, the employer would actually just need to lay him off. And so if it were me and my employer said that to me, I would say, just write me a letter that says you no longer have needs of my services because you don't want to pay me anymore, so that later on you're not going to go back to unemployment and say, oh, yeah, we don't have to pay this because this guy resigned. Look, here's his letter of resignation.
Right. Very good.
All right.
Thank you, sir. Have a good day.
Hey, no problem. Good luck. Ooh, boy. See, that's a little, just want to make sure that the employer isn't playing both sides of it. And to be clean, if the employer's really, up and up, just to be clean, it's best to do it that way, not tell the employee to, quote, resign, because then you create a problem where they're trying to explain it to unemployment. Well, I resigned, and unemployment's going to say, well, you resigned. Well, I didn't really resign. My employer asked me to resign. Oh, okay. So that could be a problem. Jim, you're on WHP 580 with Carl Rominger. What's going on, Jim?
Hi, Carl. How are you?
Good.
Hey, been living in my house 35 years out in the country. The local farmer, big farmer, just decided he has a bird problem.
Okay.
He's setting off things that sound like high-powered rifle shells 3 times a minute all around his farm. I'm hearing thousands of rifle shots every couple of days.
Mm-hmm.
Do I have to put up with that?
Well, the short answer is Maybe. Generally, you have nuisance law on your side, but there is some protection for farmland activities under the nuisance laws. There's just some statutory protections there. So I don't know the answer. And what I mean by that is we'd have to analyze whether or not he falls within the exemptions that are given to farmland. But I suspect you may be able to do something about it. I suspect.
Okay, how would we find out, Carl? Because I don't need to make neighbors or need to make enemies if I'm going to lose. I counted these guys as my friend. I go down and talk to them. They basically tell me, "Hey, we know it's a nuisance. There's nothing we can do about it."
Right.
And I said, "Well, that's not my problem."
So let's do this. What we would do is we do a little research, basically flesh out the odds of winning. It can't be the first time a farmer's been setting off noise devices for getting rid of birds, so there might even be a case or two out there on it, and go from there. And then if we thought you had a high probability of winning, we'd write him a nastygram that says cease and desist or else we're going to sue. And if we had a low probability of winning, we might still want to approach him and say, what can we do to minimize this?
Okay. And who would I talk to in your office?
Ask for me on this one. This is right up my alley.
Okay. I will call you Monday morning.
All right, brother.
Okay, Carl. Hey, I appreciate it.
Hey, thank you.
You bet, man. Bye.
540-0580. Carl Rominger here answering your legal questions. Of course, don't forget to go to weekendappointment.com where you can download the free will kit. What is that? That's a free will. You get it. You fill it out. You send it in. I just did one yesterday. Sent somebody home with their brand new spanking free will, all signed, sealed, delivered, notarized, ready to go. Hopefully she doesn't need it for a long, long time. But, hey, you never know. 540-0580. See you guys after the break. Hey, welcome back. Carl Rominger here answering your legal questions. Who's up next? Well, Eleanor, what's going on?
Hello.
How are you?
Fine, thank you. I'm curious as to who has the right to declare someone with dementia or Alzheimer's with someone else having the power of attorney. You know, when does that power of attorney kick in?
Well, power of attorney doesn't kick in. It's always in play, meaning once you sign a power of attorney over to somebody, they can use it at any time. Whether it becomes unrevocable is when the incapacity begins, and that's a combined legal and medical question.
Okay. Must it be a psychiatrist, or can it be a family doctor or a cardiologist who will declare the person?
I think that anybody with an MD would be able to do it, but a judge would ultimately make that determination if there's disagreement over it.
So it could go to court.
Oh, yeah, absolutely. Absolutely. If somebody's trying to declare somebody incompetent or somebody says you're incompetent, what would happen is, like if you said I was incompetent and I said, no, I'm not, I revoke my power of attorney and you don't need to do anything for me, that would become a legal question. But realistically, what I would do if I were representing the family who wanted to declare somebody incompetent at that point, rather than worry about the power of attorney per se, we might just go straight to a guardianship, because that way we can get somebody appointed as guardian as well. Although POA would still be effective, but you're still going to have a legal battle over it, so you might as well just run through a straight guardianship proceeding.
Okay. All right. Thank you so much.
All right. Good luck.
Thank you. Bye-bye.
Well, let's see. Now, here's the million-dollar question. Was our caller being accused of being incompetent, or is she accusing somebody of being incompetent and wants to know the answer? She sounded competent to me. I'll testify on her behalf. 540-0580. Cheryl, you're on the air. Hello, Cheryl. Cheryl.
Shirley?
Yeah, Shirley. Oh, Shirley, I can't read.
Okay. Now, I just wanted to know if you've been married for 40-some years and one dies, you don't have a will, what happens? Is it tied up with the state?
Is it tied up with the state? The short answer is no. I mean, if there's no will and you have a married couple, presumptively everything goes to the other spouse. What's going to be a problem is if anything's only in one person's name, we're going to have to go and open an estate to transfer it over. But no, we would just make the one spouse the administrator of the other person's estate. However, it's foolish to die without a will for two reasons. Number one is you're leaving it up to chance, and the law could always change, and there's a lot of different things you should worry about. But more importantly, you can get a free will at weekendappointment.com and send it in, and then you don't even have to worry about not having a will.
Okay.
All right?
Okay. Thank you.
Good luck. I know, with those free wills at weekendappointment.com, again, there's no excuse to die without a will if you live in the central Pennsylvania area. And while I do write a lot of these, I'm not writing enough of them. So get on that website, download that thing. And by the way, if you're somebody, I know somebody's sitting around going, Carl, I don't understand how to get on a computer. I can't even use my iPad. I'm not even sure what an Apple ID is. Well, if that's you and you're just trying to figure out how to get that kit, if you call our office at 241-6070, again, that's 717-241-6070, and that's you can leave a message, leave your name and address. We'll send you out the kit, or you can call in during the week, and one of the ladies or men there will take your information and we'll send you the kit. So, again, if you're somebody out there who wants a free will but can't get it online, and you really should get it online if you can because it's so much simpler, but if you can't, we understand. Just call 717-241-6070, and we'll send you out the kit. Ken, what's going on?
I got a two-part question for you.
Yeah.
First is I recently got separated about 4 months ago, and I was married for 15 years, and we have a house involved, no children. I'm older. She sent me papers that say she wanted a divorce, and all it said in there is that she's suing for divorce, and that's it. There were no terms of conditions of house or alimony or nothing in there. And
right.
Telling me that's the start of the procedure. Is that true? That you first got to file and then you go into court, or you go into mediation for what happens to everything?
Yeah, generally that initial filing is not going to really explain in detail what anybody wants. It basically says we were married, we don't get along, we want to get divorced. It might include a provision that says we want to split up the property. It might include a provision that says I want alimony, and it might say I want attorney's fees or blah, blah, blah. But it'll never say what they are or what they mean exactly.
Okay, yeah, so it's very short and to the point. There's nothing spelled out at
Correct.
all. The other question I had for you is we own this house. Last year we had to claim bankruptcy, although we kept the house, okay?
Right.
And then all this happened, and I told her she could have the house, but my name is on the deed and the mortgage as well as the title and everything. Now she's telling me that a lawyer is telling her that I can get off of the deed, but I have to stay on the mortgage. And does that sound even feasible?
What?
Because she can't refinance the house on her own.
Right.
Without my credit as well as hers, both shot. So the mortgage company would not refinance, and I don't want to see her lose the house or us, lose the house or whatever. I'd rather see her keep the house. So what is my solution to that? I don't want to be responsible down the road if for some reason she doesn't make payments. My credit will go back down the hill as I'm trying to build it.
Yeah, and so let me tell you, you're in a common dilemma. The short answer is never, ever, ever in a divorce, general rule, stay on a debt obligation but take yourself off the deed, okay? That makes no sense because now you have the worst of all worlds. You have no ownership interest in the property, but you have all the ownership interest in the debt, or equal ownership interest in the debt. So what we would recommend, and usually do in a case like yours, is come up with a scheme that says, okay, either side who wants to keep the house has so much time to refinance it. If they can't refinance it, it's going to get sold under these terms, and this is how the money's going to get split, yada, yada, yada. But, yeah, you're going to want to get some detailed documentation put together there. And also, you probably need your own lawyer. In other words, don't take the other lawyer's advice, because if I represent your wife and I'm talking to you, trust me, you really don't want to rely on what I tell you.
All right. So
I can't.
Suggest somebody to call? Can I call your office?
Yeah, Robert Culling in my office would be the best guy for a case like this.
Name again?
Robert Culling.
Robert Culling.
And the office number is 241-6070.
241-6070. Okay.
All right, brother.
Thank you.
That's really important, folks. I get this all the time. People say, well, the lawyer told me. And I'm like, whose lawyer told you? Well, the other side's lawyer told me. Oh, he did? Really? He told you? See, here's our rules. I can't actively deceive you, okay? I'm not allowed to lie to you. But let's just talk about what a lie is. A lie is like, from a lawyer's standpoint, what is a lie? A lie is a willfully false misstatement. It might be leaving out an essential fact, but there's so much wiggle room, that when you ask the other lawyer a question like, well, is this a good deal? Sure, it's a good deal. You didn't ask what it was a good deal for, did you? So that sounds like an honest answer. Or, is this the right thing to do? Should I sign it? Sure, you should sign it because it's in my client's best interest. Or, is this legal? Well, of course it's legal, Doesn't mean it's the best way for you to go. So you can think about all the different ways you might ask a question, and unless you're probably going to nail everything down, plus you're not even going to know what's normal. So another lawyer I was talking to the other day was telling me about a client of theirs who signed over custody of the child, 18 different ways in a document that at the end of the day gives them absolutely no actual rights whatsoever. But it's very lengthy. It's very official looking. It was drafted by a lawyer and filed with the court. And so this poor fellow was surprised to learn that he didn't really have any enforceable right to his child whatsoever. Because, well, why would that happen? Because he thought the other lawyer was looking out somehow for his or her best interest, or in this case, his best interest. So put that in the back of your head. When you're talking to the other lawyer and they say you can do it this way, or this is the way I'm proposing we do it, that doesn't mean that they have your best interest at heart. And in fact, I've joked with clients before, when the other side's unrepresented, we'll send them a lopsided agreement, and if they're dumb enough to sign it and send it back, consider yourself lucky. And there's no misstatement or anything there. If we send there's no requirement that an agreement not be lopsided, that I don't take the lion's share. But some people just assume somehow that what they're getting is going to be fair or it's going to accurately reflect what a court would do. And that's just not the case. So that's your admonishment for the hour. 540-0580. Next up's Dennis. Dennis.
Yeah, I got a question on foreclosed properties.
Yeah.
I was looking at one on the sheriff's sale list, and then it was taken off. I called the lady at the courthouse, and she was nice enough to give me as much information as she could. So I called the mortgage company, and they said, not attorney-client, but they couldn't give me much more information. And I talked to the lawyer, and he said the same thing. My question is it easier for a lawyer to get information out of a lawyer than it is an individual like me? I mean, that's kind of a dumb question. It probably is, isn't it?
Well, the short answer is maybe. The long answer is, and I in all sincerity, I know it's easier for me to get through, for instance. So here's how I do it. I return a phone call. I say, this is Carl Rominger returning attorney so-and-so's phone call. And sometimes if they know me, they go, oh, okay, attorney Rominger. So if I know the other lawyer's office doesn't know me, I say, this is attorney Rominger returning attorney Smith's phone call. And that's because it gets you through the secretary a little better. Honestly, and this is something my clients probably know how hard I can be to get a hold of sometimes. And it's because we're in court. We have a lot of stuff going on. We have a lot of deadlines. We have to work on what's going on. But, I mean, I remember going to court one day, and I came back, and I had 47 phone messages, okay? I mean, what order do you want me to call them back in? Because I'm still not getting back to anybody for 3 days. So it wouldn't matter who went first. You know what I mean? So, yeah,
okay,
but you're right.
But I'm saying right now, the bank couldn't give me any information. The attorney couldn't give me any information. But it's the way I understand it's still out there to be bought, but I can't get any information from anybody. The guy that owns it obviously isn't going to answer the phone because he's mad because he's losing
yeah.
it. It's still for sale, but I can't get any information from anybody.
Yeah, and your best bet would be the attorney who's handling the foreclosure.
Well, he won't give me any more information. He said that's attorney-client.
Right, and maybe he doesn't have to give you any more. He doesn't care because it's going to go to auction eventually, right?
Well, it was on the sheriff's sale, but it got canceled. Canceled doesn't mean that they paid for it. It just means it's not for sale right now. So what? If I'm still interested in the property, what's the next step you do to try to get information?
Here's what I would do. I would go to the bank. Well, again, this is tough. I would, and this is the problem. It used to be a little easier. Is it a big bank like Bank of America, one of these giants?
Similar, yeah.
Yeah, see, if it was a local bank, it'd be easy. You just go to the local bank, find the guy who's in charge of the situation, and they'd probably be happy to help you buy it off of them, right, rather than foreclose on it.
Right, that's what I figured. It's Chase something, but yeah.
Yeah, and the big guys, they don't know the left hand from the right hand. The short answer, it might help you. It might help you to have a lawyer interface with the other side and just see if you can learn any more. What are you trying to find out about this place?
Well, if I could buy it, the way I understand, it's for sale, but I can't. They won't. That's all I know. It's still for sale.
Here's what I want you to do. If you hold on for a minute, Shane will give you the contact information from my realtor buddy Paul Chase. And why don't you talk to him, because he I know works with foreclosures, short sales, and distressed properties all the time, and he may actually know who to talk to at the bank.
Okay.
Especially the big bank. You want to hold on here and Shane will get you Paul's contact information?
Okay, thank you.
All right, hold on. 540-0580. We got to go to break here, folks. When we get back, we'll answer questions for John and Joe. Oh, it's true. I say this every time Shane plays that song. I can't drive 55. Drive the speed limit, 65. Of course. 540-0580. John, you're on the air. Hey, John.
Carl. Hey, my wife and I are in our final months of our Chapter 13 bankruptcy.
Okay.
And we have several of the people that have been paid off putting charge-offs on our credit report. And I thought we weren't going to have anything negative after the bankruptcy. But are there, this may not be your area of specialty, but are there, sorry, that's my
The GPS is talking.
Yeah. Are there that specialize in
there are attorneys out there that advertise credit repair, and I mean, some of the credit repair stuff is kind of scammy, and what I mean by that is, I mean, it's like, okay, send letters of dispute and constantly dispute it, so they have to put it as disputed and can't hold it against you, you know, but the long and short of it is, I don't know the answer on that. I don't know if there is a, quote, legitimate way, for instance, to remove a charge off like that from your credit report.
Okay.
All right.
All right.
Wish I had a better answer than that. I would surf the internet a little bit and check it out. But like I say, a couple of things I've seen over the years, they just seem a little fishy. You know, it's sort of like, reminds me of the guy that says, oh, no, you don't have to pay postage. You just put a 2-cent stamp on, and then the other guy will always have to pay postage due. You know,
right.
Technically illegal. Probably not a great idea, and it's not going to work forever.
Right. Yeah, most of them are pretty scammy. They're like $1,000 or something.
Yeah, that's what I'm thinking. It just, you know what? If it walks like a duck and it talks like a duck, it's probably a duck. And if it smells like a fish on the beach, it's probably a fish on the beach, right?
Right, but I think there's some money in a fine for those posting negative information when they're not supposed to.
Yeah. Oh, yeah. No. Under the Fair Debt Collections Practices Act, if you can whap them. In fact, if I could figure out a way to reliably make money at that, that's probably what I would do. Right.
Yeah, that's what I thought. There might be an attorney in that kind of field that'll take a 60-40 type of thing.
Yeah.
You know, that's what I was kind of looking for.
If you go to, I have a website, romingerlegal.com.
Okay.
If you go there and click on the attorney link, there's an attorney matching link. You could post your case on there and see what happens.
Okay.
All right?
Sounds great. Thanks.
All right. Good luck, man.
Bye.
Well, I don't know. We'll see. I always do think those things sound scary. Yeah, write a letter and you dispute it. And I'm like, but you're disputing it. But what's the basis for it? No, you just dispute it. All right. Put those 2-cent stamps on. Joe, you're on the air.
Hey, how's it going? Thanks
Good.
for taking my call.
What's going on?
Okay, so I lease a commercial property in York. It's a pretty simple one-page lease with 60 days notice to quit on either side of the coin. The problem I have is a week before Thanksgiving, we had a storm and it knocked out power to my section of the building, which rendered it useless. So I haven't paid rent until the problem's been remedied, and it's not been remedied, so I'm moving out. Here's my problem. I go today, and I see a notice of hearing taped on my door from my landlord, and the amount he's claiming is roughly 5 times my monthly rent, and I owe him 2 months, and he has a 1-month security deposit. It also says that notice to quit was given, which it wasn't, and he's named instead of naming me who the lease is with, he named a company who I'm associated with currently, but not when the lease was signed. And the hearing is dated for this coming Thursday, and he's already changed locks without an order of possession.
Right.
It would seem to me that I have a little bit of experience with landlord-tenant stuff because I own some residential rental properties, but it would seem that something's not right here, and I should probably not go to that hearing without a lawyer. Yeah,
it sounds to me like there's something going on there. The short answer is you're not supposed to do self-help, so you may have a good argument there.
Yeah, because I knew I would get in a ton of trouble if I locked somebody out of their apartment without an order of possession.
Right.
Or actually even without the constable coming, because I can't change locks without the constable being there.
Right, right.
So it's kind of short notice. Is there anyone you can refer me to, either in your office or not?
What's the date of the hearing?
This Thursday would be the 12th.
Okay, yeah, we can cover that for you. What I would ask for Steve or Rob.
Okay, what's the number to your office?
241-6070.
6070. Okay, and they're in Monday morning?
Yep, we'll be in there.
Okay, appreciate it. Thank you.
All right, my friend. Take care. Yeah, it doesn't sound right. You can't. Landlords don't pinch the gas line. Don't lock the tenants out. Go through the legal process first. Get your judgment of possession. It's always the better way to go. Dennis, you're on the air.
Yeah, how you doing?
Good. What's going on?
I got a question for you. And by the way, I highly recommend you. I used your office for a couple of things now, so I'm really glad that you're available.
Oh, thank you.
So the question I have is, 5 years ago, my daughter-in-law took off with the kids, kidnapped them, took them to Virginia. We got them back to an attorney down there in the courts up here, and then she had no contact for 5 years with these kids. And my son is still legally married to her. Went on YouTube and saw a video of her wedding in Virginia. Now, I'd like to know how she was able to get married without getting a divorce first up here. Are we looking at some legal issues here?
Is she not divorced yet?
No, he's never got. As far as the state of Pennsylvania states, he legally married to her.
Yeah, well, and there'd have to be a divorce. In order to be a divorce, he'd have to be served with it. So she may be guilty of a crime we call bigamy.
Okay. I mean, there's no judge in Virginia that could give her one without us knowing, is there? I mean, can they do that down there, or? She might have claimed that she was abandoned for 5 years.
Right. She may have.
She made contact with her dozens of times.
Yeah, she may have successfully been divorced. So that would be something to check out, I guess. I mean, that's the first thing to check out.
Yeah, because and she can't come up here because she got a warrant for an arrest up here off of PFA. So we're kind of just figuring out what's going on here because he's still getting child support from her and stuff. But now she wrote him and wants to see the kids and all kind of stuff. And there's something fishy here. I just don't know what's going on, and I just want to make sure that base covered. So I may have to use your office again.
Well, I appreciate it. It. If we can help you, we will.
Okay.
I mean, I don't know what to tell you about the divorce. I mean, in terms of the other issues, we certainly can follow up on them.
Right. I mean, since they got married up here, wouldn't that stuff have to be done up here, or can a state override another state?
You can get divorced in a different state than you were married in.
Okay.
But you have to have residency there. So I always tell people, too, by the way, if a spouse moves out of state and you want to keep the divorce in the home court, you want to make sure you file within 6 months, because after 6 months passes, the new state has jurisdiction as well as the state where the other spouse is living.
Oh, so maybe that's what happened. Maybe she got a judge to believe a story or something, got a divorce without us knowing. Then
yeah, it's quite possible.
Okay, well, thank you very much.
All right, my friend.
Have a good one.
All right, take care. Yeah, I don't know what to tell him except, all right, well, Bob, hold on here. 540-0580, 540-0580 is the talk line number. I'm going to be answering your legal questions for the next hour here live on the air, so call in. In the meantime, if you ever need to get a hold of us during the week, just go to RomingerLaw.com. You can contact our law firm that way, or call 241-6070 in the 717 area code. Again, the talk line number is 540-0580. See you guys in a few minutes.